Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Look, today what I've got for you is a little more tame legal analysis of Mark Waid's motion to dismiss for lack of personal jurisdiction against Richard Meyer, otherwise known as Diversity in Comics, in this the Comicsgate lawsuit. So I am going to go through. I have already gone through the document. I have highlighted the relevant legal arguments involved with the jurisdictional matter. There's a bunch of other crap thrown into it, frankly, and that stuff is there to psychologically influence the person who will be reading the document, whether that be the general public, whether that be the judge. This is pretty common. Obviously, you are advocating for your client in whatever way that manifests, and part of that will be to try and persuade people that your client has a moral imperative or a moral reason for doing what they did. So, we're going to skip all that because none of that actually matters in the jurisdictional argument. This is a highly fact-specific legal argument, pretty much relegated to general jurisdiction. So this video is going to focus heavily on that. So we're going to go through. I will read the highlighted portions. I will comment about them. We're going to just take a real look at the analysis there. And then I will go through. And by go through, I mean I'm going to comment on one of their citations that they rely on pretty heavily to make their claim, and talk about the positives or negatives that may be associated with that. With all of that, if you're expecting a lot of ranting and screaming, I did all that beforehand. This will be a very measured analysis, similar to my Truth as a Defense video. If you have not seen my Truth as a Defense video, check it out. If you want the level legal analysis, check that video out. If you want the firebrand ranting, and sometimes that's what you need, you've got to watch the live stream in which I went through this document. It's 3 hours long, so that's up to you. Some people like that kind of stuff. Some people like this kind of stuff. This is a more open legal analysis, and I'm going to try and be as unbiased as possible in that analysis based on the facts that are publicly available and based on the arguments made in this thing. The reason that I'm doing this is because we will see a document like this come across in the next couple days to 2 weeks when Meyer gets to file his response to this motion, where they will oppose the motion to dismiss for lack of personal jurisdiction. And they will make legal arguments that I guess and hope will be similar to the arguments I'm making. It is possible they will use, they're going to use more legal authority. They're going to do a more thorough job than I will, but this should give you an idea of the direction that they're going. Caveat to all of this, of course, is that I do not practice in Texas and I do not practice in federal district court. So I am not going to be familiar with particular authority that they might commonly use down in Texas, and I am not going to be familiar with any particular procedural aspects that may be unique to the forum, okay? But I have done a entry-level bit of research on this to kind of talk about where these arguments are coming from and where they're likely to go. What are the good parts about them? What are the bad parts about them? And there are good and bad parts to this document. So with that, let's jump in. All right, so this is Waid's motion to dismiss for lack of personal jurisdiction. We can skip the introduction mostly because it's just, how great Mark Waid is, which is fine. That's not a negative thing. Zach did the same thing in his initial complaint. He talked about his upbringing and all that stuff. But here we go. Waid did not even know that plaintiff apparently lives in Texas, particularly in light of plaintiff's effort to create the public impression he lives in New York City, as discussed below. Now, the public impression that he lives in New York City that they discuss below is just that his Twitter profile says he lives in New York City. There's a lot of reasons to not necessarily represent where you are on Twitter. Some of that has to do with privacy. The rest of that may have to do with when you created an account or when you updated a profile. You did live in a particular place, or you were in a particular place at the time, and you have since changed places. That doesn't really mean that that's the only source that one would use, and that doesn't necessarily defeat jurisdiction. But I just want to point out that this is their argument, that because Wade did not know that Meyer lived in Texas, they're alleging that he could not have purposefully directed any conduct towards Texas. This is going to get heavily into the citations that they use, where with specific jurisdiction, a defendant has to have purposefully availed themselves of the forum. And they do that by directing activity to the forum. So if they could show that Wade knew that these events and all of this stuff was happening in Texas, and that he entered into the forum state in some way, not physically, but in a either physical or metaphysical sort of way, he directed his activity into the forum state, that he willingly conducted a tortious act, or what could be considered a tortious act within the forum state, then if they can show that, then they can probably exercise jurisdiction over him. Because if you're entering the forum state to commit some sort of tortious act, then you're going to expect to be hailed into court in that forum state and not somewhere else. So that is where that ends up. This is why they're making that argument. Let's see how it unfolds. Let me dispel something right away with this next highlighted line. The book plaintiff seeks to publish is not about Texas. I mean, this really doesn't matter. Because if you're publishing a book about Texas, it's not like you're going to be defaming the state of Texas, probably. And if you're publishing it to be distributed elsewhere, it doesn't really matter if it's about Texas or not. What matters is the location of the person publishing the book. What matters is where the publishing is taking place. What matters is where any contracts or agreements or business may be done in regards to the book. So they bring this up a lot, but this is a really minimal sort of thing. And I mean, I guess it could in some theoretical way tip the scales one way or another as to some subject matter relating to Texas. Or maybe they would make the argument that, well, if it was about Texas, he would be more knowingly engaged in Texas activity. But I don't think that that would actually hold water. And I think that if this book was about Texas but being published in Wyoming, that they would argue that even though the book's about Texas, all of this stuff is happening in Wyoming. So it's a weird toss-in, but it's not really important. Okay, factual background. Mark Wade has no connection to Texas. I mean, I don't think this is true at all. This is actually certainly not true that Mark Wade has no connection to Texas. Mark Wade does business in Texas. Specifically, he attends conventions in Texas, like Comicpalooza 2018, which he attended at the end of, I believe, May 25th, 26th, and 27th. He did interviews at Comicpalooza. He was present for book signings, and he sells merchandise in Texas. And people could buy merchandise in Texas that's related to Mark Wade while he's there. I can't personally attest to them being able to buy merchandise from Mark Wade in Texas because they might have been buying it from a convention or some sort of vendor. But we do know that at some point Mark Wade was offering signings, free signings attached to the purchase of a Mark Wade property or a Mark Wade book. Okay, so he does have a connection to Texas. Question is not whether he has any connections in Texas. Question is whether he has substantial connections in Texas to exercise general or personal jurisdiction over him. Let's see. Mark Wade is a citizen of California and lives in Santa Monica. Declaration of Mark Wade attached as Exhibit A. Works from California as a freelance author of comic books. He does not maintain any agents for service of process in the state of Texas. He was served with the summons at his home in California. If he maintained agents in Texas, that would mean that he definitely was personally availing himself of Texas and indicating that he was expecting to be hailed into court there. So since he doesn't, that argument goes mildly in his favor, but it is far from conclusive. Mark Waid has no interest in, use of, or possession of any real property within Texas. He does not own or lease any personal property in Texas. He does not have any bank accounts in Texas. Does not maintain any assets in Texas. He is not required to pay any income, business, or property taxes to Texas. But he probably does pay sales tax in Texas. And the reason he doesn't pay income tax in Texas is because Texas doesn't have an income tax. So while Mark Waid doesn't pay any income tax to Texas, if he did business in Texas, he would have to pay income tax to Texas if Texas had an income tax. But since they don't, that part really doesn't matter. He can still do business in the state of Texas personally. He could work there without incurring any income tax. And in fact, him showing up at a Comicpalooza, depending on the nature of the agreement, him showing up at various stores may otherwise constitute work in Texas without incurring income tax because, again, they don't have it. So that's not really a useful statement in that sort of context. He does not regularly do or solicit business in Texas, nor does he have any ongoing business relationships in Texas. I think this is fuzzy because he does go to various businesses in Texas in his capacity as a freelance writer and engages with audiences there. That is doing business in Texas. That absolutely is. Whether that's significant enough and related to the transaction in question remains open. He does not have a mailing address or telephone number in Texas. He lived in Texas in the early 80s when he was young, but he has not lived in Texas since. None of Mark Waid's infrequent visits to Texas have anything to do with the allegations or people or entities identified in plaintiff's lawsuit. This is showably, factually, demonstrably untrue. This is untrue. Mark Waid does have appearances in Texas that matter specifically to this lawsuit, and we'll discuss those a little bit later. Mr. Waid has worked in the comic book industry for more than 35 years. He has never had office space in Texas, does not recall any colleagues with whom he would work regularly in Texas. Therefore, at the time of the alleged events in this case, including in 2017 and 2018, Mr. Waid had no connection to Texas, except he did. Again, he was at Comicpalooza, which was in Texas. He did interviews in Texas. Most importantly, he contacted a business owner in Texas to discuss a Texas contract. Let's briefly address this. The alleged contacts concerning Mark Waid's connection to Texas are at most random, fortuitous, and attenuated. Now, this is untrue as well. Random means by happenstance, by chance. Fortuitous means a similar sort of thing. It falls into the lap of the person. Fortuitous would also be a synonym of random, but with a positive slant to it. And attenuated means that they are weakened or lessened. Mr. Waid's connections to Texas are not random, fortuitous, or attenuated. Mr. Waid's connections to Texas are intentional. He enters into the state to conduct business at Comic Cons. He does go to business locations in Texas to conduct signings. I believe he did one in Houston at the Westheimer branch of some store, very specifically. That is not random, fortuitous, and attenuated. It was announced. It was arranged between the parties. So that statement is demonstrably false as well. Next, so this is what I was talking about earlier. Plaintiff's DNC Twitter page did identify at times relevant to this lawsuit and currently identifies New York as his location. Doesn't really matter. Not a book involving any story about Texas or one aimed only at Texas audiences. Now, if this was marketed only in Texas, I guess that would matter, but this statement again doesn't matter that much because the contract was in Texas between two Texas residents. That's what really matters in this case. So then he talks about Malin, Van Sciver, and Smith's Twitter profiles indicating that they're not in Texas. Again, that doesn't matter. This isn't alleged tortious interference with these guys. These guys are ancillary to the tortious interference claim, and all of their relationship to this book doesn't matter at all and isn't even brought up in Meyer's complaint. But it's interesting that, he would cite all this because Antarctic Press's website states very clearly that Antarctic Press is a Texas company based in San Antonio, I believe. And if he's researching all of these other people, he's researching everybody else, he certainly doesn't seem to be researching the one of the parties that is very openly and publicly a Texas company. Mr. Wade made 2 or 3 social media posts on Facebook and Twitter regarding plaintiff. These posts were not directed at Texas, but rather were posts accessible and viewable by all of his more than 5,000 Facebook friends and nearly 100,000, not 100,000 Twitter followers, regardless of where they're located. This is an argument that's predicated on one of the cases they have coming up called Revell. And if you want a nice Easter egg that was thrown into this motion, go read the case. I'll get you the citation in a minute when it pops up, but it's Revell versus Livbin or something. Livin. It's in here, but it's a nice Easter egg involving Zaid. Very clever, very clever. Mr. Wade had left a message at Antarctic Press and asked that someone return his call. Mr. Wade left a message. That means he contacted Antarctic Press, who has a Texas area code because they're a Texas company. The number you call to contact Antarctic Press is a Texas phone number. Mr. Wade contacted Antarctic Press. He called a Texas phone number. He availed himself of Texas. He entered into the forum in a metaphysical manner. This is going to be a very big distinction from one of the big cases that they rely on in making their jurisdictional argument. I also believe that he's lying here, and I'll show you why later on in the video. Mr. Wade did not know where the person was located during this phone conversation, whether in Texas or somewhere else. Yeah, because you never know where someone's located, but you know you're contacting Texas. Mr. Wade had no knowledge that Antarctic Press had any operations in or connection to Texas. I believe that's not true. Mr. Wade did not know where Antarctic Press was located, having retrieved only a phone number from industry contacts, a phone number with a Texas area code. And Mr. Wade does not know where the person with whom he spoke lived, whether in Texas or elsewhere. Mr. Wade did not know that plaintiff resided in Texas or had any connection at all to Texas. I also don't believe that this is true in the sense that I think he's now claiming ignorance. But if he knows as much about Meyer as he says, then where he believes that he has done enough, listen to the contradiction in logic here. He knows enough about Meyer that he's saying that AP didn't know enough about Meyer, but he does. He knows enough that he must rescue Antarctic Press from what's going on because he knows enough about Meyer, but he alleges that he doesn't know the state in which he lives, where a lot of other people did at the time and do still today. Now, I'm going to briefly address this section. Plaintiff's own words and conduct directed toward the world, not just Texas, have created substantial reason why plaintiff may not do business with him. This is not a jurisdictional argument. This is an argument about the merits of the claim, and we're going to ignore, I think, all of it, because none of this matters in relation to Texas and why Texas would have authority over Wade. So, skipped. So now on to the argument and authorities. Court lacks personal jurisdiction over Wade. All of the beginning of this paragraph is useless. The end statement matters. At the outset, however, this court respectfully does not have personal jurisdiction over Mr. Wade. The legal standard is Federal Rules of Civil Procedure 12b-2. A court must dismiss an action when it lacks personal jurisdiction over the defendant. That's fine. Now, while uncontroverted allegations in the complaint must be taken as true, the court is not required to, quote, to credit conclusory allegations even if uncontroverted. So, the way the court has to read the complaint is that the complaint has to be taken as true and read in the light most favorable to the non-moving party, which would be Meyer in this case. But the court doesn't have to credit conclusory allegations even if they're not controverted at the time. So if they're not contested by the opposing party. Conclusory allegations are legal conclusions that are put into a thing. So-and-so defamed so-and-so. That's a legal conclusion. That doesn't have any weight in a complaint. What would have weight is a set of facts that lead a decision maker to the conclusion of defamation. There's a difference between saying someone did something and showing how someone did something. Show, don't tell, right? Your good literary argument there. In deciding a Rule 12b2 motion, the court may consider evidence. And that's why they've included tons of evidence, approximately 80 pages of evidence, which will not be addressed in this video. I will address some other evidence that may be introduced by Meyer in his response. I don't know if he will. If I were doing it, I would introduce it because I think it's pretty important. All right. So this goes into how the court will exercise jurisdiction. That's through something called a long-arm statute. And in the case of Texas, the Texas long-arm statute extends to the limits of federal due process. The two-step inquiry collapses into one federal due process analysis. So Texas long-arm inquiry says as long as the feds will let us go as far as possible, we will exercise jurisdiction. So at this point, we only have to analyze what the feds will allow. Due process is satisfied when the non-resident defendant purposely availed himself of the benefits of and protection of Texas by establishing minimum contacts within the state of Texas, and the exercise of jurisdiction does not offend traditional notions of fair play and substantial justice. Not subject to jurisdiction based on random, fortuitous, or attenuated contacts. I've already discussed this. Random, fortuitous, and attenuated in no way describe the contacts that Wade does have. General personal jurisdiction is unrelated to plaintiff's cause of action and requires that the defendant have continuous and systematic contacts with the forum state. This is a weaker argument for Meyer. I think they can still make the argument that Wade engages in business activity in Texas with regularity. All they have to do is pull up his attendance of cons in Texas and just go ahead and cite them. And if he has future plans to attend Comics Palooza again, or any other convention or stores in Texas, then they can show that he has continuous and systematic contacts within the forum state. But continuous and systematic contacts between different businesses and different conventions might not meet the general jurisdiction standard that's laid out in Helicópteros Nacionales, or more importantly, International Shoe. It may not make the standard that is laid out for this. Like I said, is a weaker argument for Meyer. The stronger argument for Meyer lies in specific jurisdiction, which we're going to talk about. Revell versus Lidov, right here. Revell v. Lidov. That's the case you want to look at for the fun Easter egg that Wade's legal team has put in. I'll let you Google it and smile. Just read the first paragraph, the synopsis, or the first paragraph of the facts section. You'll find out very quickly why it's a fun Easter egg. But I won't spoil it. That's up to you guys. Specific jurisdiction requires, among other things, that the defendant's contacts with the forum state arose from or directly relate to the cause of action, and they say neither exists in this case. Again, I'll disagree. Plaintiff cannot establish general jurisdiction over Mr. Wade. Mr. Wade has no presence or even property in Texas, but he clearly does have a presence in Texas. It's just sporadic, or not even sporadic, sparse maybe, but it is impactful. He's going and marketing directly to fans and directly to businesses and directly to publishers as a freelance artist or freelance writer. So I would suggest that he does very much have a presence in Texas. Mr. Wade cannot be said to be at home in the state of Texas, which is obviously a lie, because if you're born in the state of Texas or lived there as a young child, you are always at home in the state of Texas. Come on, Mark, you know that. He simply has no contacts with the state of Texas, not true as discussed, much less any supporting the exercise of general personal jurisdiction. That may be true. Specific jurisdiction is a claim-specific inquiry. Plaintiff bringing multiple claims that arise out of different forum contacts of the defendant must establish specific jurisdiction for each claim. So yes, if they do have to rely on specific jurisdiction, which they may, then they have to make the case for tortious interference and for defamatory, the defamatory comments, defamation. They may not be able to hold specific jurisdiction in the defamation claim. I'm going to be very frank. That gets really thin really quickly. There's still an argument to be made there, and we'll discuss it as it goes, but it is very thin. Let's see. So here it's a 3-step analysis for this. Whether the defendant has minimum contacts within the forum state, i.e. whether he purposefully directed his activities toward the forum state or purposely availed himself of the privileges of conducting activities there, whether the plaintiff's cause of action arises out of or results from the defendant's forum-related contacts, and whether the exercise of personal jurisdiction is fair and reasonable. The third one is absolutely yes. If you can show the first two in this case, it is absolutely fair and reasonable. Mark Wade will have no trouble, as he has hired a DC attorney to help him fight a case in Texas. Mark Wade will have no trouble fighting in Texas. It is absolutely fair and reasonable. He can appear and do most of his stuff remotely, and he may not have to make any personal appearances. He may be able to make them entirely by teleconference or something else. So to say that it's not fair and reasonable would be silly if you can show the first two. So the defendant's relationship with the state must arise out of the contacts and that the defendant himself creates within the forum state. Now, we know that Mark Wade initiated contact with Antarctic Press. Antarctic Press did not initiate contact with him. They may have returned his phone call, and they may be hanging their hat on that, but they have admitted that Mark Wade called to initiate contact and left a message with AP's secretary, I think. So Antarctic Press did not initiate the contact. Mark Wade did. He himself created that contact within the forum state. Due process requires the defendant be hailed into the court on a forum state based on his own affiliation with the state, not based on the random, fortuitous, or attenuated contacts he makes by interacting with other persons affiliated with the state. Well, he contacted a Texas corporation, as stated multiple times. For a state to exercise jurisdiction consistent with due process, the defendant's suit-related conduct must create a substantial connection with the forum state. A substantial connection. They're going to go and talk about the business connection here, but the substantial connection is that they engaged in tortious activity in the forum state based on their connection with the forum state. So here they say that it is fleeting and unintended contact between Mr. Wade and Texas, but it's not unintended. You contacted a Texas corporation about a Texas contract between two Texas residents. That's not fleeting or unintended. They're trying to make the fleeting and unintended seem like he was too dumb to understand that these people were all in Texas. That's not fleeting and unintended. Fleeting and unintended would be if a Texas person contacted him out of the blue. It's not his responsibility to know that that person's in Texas. That's not what happened here. Even contracting with or being employed by a Texas company without significantly more is insufficient to establish the requisite minimum contacts for jurisdictional purposes. Sure, if the Texas company contracts with you, but everything happens outside of Texas, that's a different story because you're not entering into the forum. You're not engaging Texas. Texas is coming and engaging you. In ANCAP, Texas engages you. Plaintiff conclusorially alleges only one insignificant jurisdictional assertion, that of a phone call between one of the owners of Antarctic Press and Mr. Wade. Plaintiff does not state how long the phone call might have been, nor does he identify where either the parties to the call were even located at the time. Plaintiff's allegations, even taken at face value, come nowhere close to establishing personal jurisdiction as a matter of law. Conclusory allegations, those lacking in location, date, or other detail, are insufficient to demonstrate that specific jurisdiction exists. Now, what they're talking about here, they're conflating the argument that some communication took place. That's a conclusory allegation. No. They know that a communication specifically between Mark Wade and Antarctic Press occurred because Mark Wade stated it would occur. They don't have the specific time and date, although they can pretty reasonably show, based on Mark Wade's own tweets, when he was going to contact AP with some pretty good, I guess, accuracy. Within a 24 to 48 hour period, they can tell when all of these conversations took place. So saying that they don't have location, date, or other detail is a little bit silly. We know that the call took place to AP because Mark Wade said it would. So where Mark Wade was isn't really relevant. We know that he contacted AP. I have a call into AP. All right. So we know that that happened. We know the date. We know the details. We know who the conversation was with. It was Mark Wade and a secretary, and then it was Mark Wade and one of the owners of of Antarctic Press. This is all stated by Wade in his own tweets and then in subsequent interviews. So that is flatly an incorrect argument. Especially in this age of mobile phones, an allegation of a phone call, even assuming tortious conduct allegedly occurred during the call, does not support personal jurisdiction. And now here is the case that they're really relying on here, and it's Michiana Easy Living Country Incorporated versus Holton. Now, this is a case in which Holton is a Texas resident and Michiana Easy Living is an RV dealer somewhere else. I don't know, probably California. It doesn't really matter where Michiana is located. What matters is that Holton initiated all of the contact with Michiana and directed Michiana to deliver the RV into Texas. Michiana chose nothing with Texas. They did not solicit to Texas. They did not invite Holton to contact them. They did not leave a message for Holton. This is very distinguishable from the case at bar because Holton initiated all of the contact in Michiana Easy Living. In this case, in Wade's case, Wade initiated all of the contact, all of it. So Wade is the person initiating the contact with AP and therefore entering into Texas to interfere with a contract with Texas. In the other case, Texas is reaching out to the other party. There's a huge difference there. Huge difference. So we've got specific jurisdiction is not established merely by allegations or evidence that a non-resident committed a tort in a telephone call from a Texas number, even if the defendant knew the plaintiff had significant connection with Texas. That's because in that case, the person initiating contact was from Texas, and that was invited upon the other party. Big difference. Big difference. Plaintiff's vague allegation Mr. Wade had a phone call with Antarctic Press does not create the type of substantial connection to Texas or purposeful availment that is necessary to support jurisdiction. Mr. Wade did not even know plaintiff was in Texas. Again, I'll assert that that's not true. Nor would anyone else know that from looking at plaintiff's public profile. In order to establish personal jurisdiction over a defendant who allegedly committed an intentional tort in the forum state, plaintiff must show as one of the necessary prerequisites that the defendant knew that the plaintiff would suffer the brunt of the harm caused by the tortious conduct in the forum and point to specific activity indicating that the defendant expressly aimed his tortious conduct at the forum. Well, if the contract is with a Texas company in the state of Texas, then you know that the damage will be done in the state of Texas. Mr. Wade's lack of knowledge of where plaintiff was located by itself defeats jurisdiction. That's not true. The minimum contacts analysis looks at the defendant's contacts at the forum state itself, not the defendant's contacts with person who reside there. And again, the contact is with the forum state because it involves a contract in Texas. Because there is no relevant connection between the operative allegations of tortious interference with contract claim and Texas, let alone a substantial connection, there can be no finding of specific jurisdiction over the claim. I'm not going to sit and hammer it home. This is the defamation claim. Again, I could go through this, but if you go back and look at Meyer's complaint, it will assert that Wade made statements that were defamatory. Those defamatory statements are that Meyer distributed a list of comic shops and their employees' names and phone numbers. That's the alleged defamatory statement, as well as statements that he is racist and other things. He is saying that those statements made on social media do not amount to defamation in Texas, and that exercising specific jurisdiction over a social media post would be the wrong thing to do. That may be a good argument. That actually is a good argument, and that's why specific jurisdiction over the defamation claim is a weak case. However, we have two interesting pieces of evidence to present in just a moment. Let's wrap up with this violating traditional notions of fair play and substantial justice. I said before, that's a 5-part analysis. Here's what it is. Fifth Circuit considers 5 factors. 1, the burden on the non-resident defendant. 2, the interest of the forum state. 3, the plaintiff's interest in obtaining relief. 4, the interstate jurisdictional system's interest in the efficient administration of justice. And 5, the shared interests of the several states. Now, they do go through all of these things and make claims that none of them apply, but very quickly, the burden on the non-resident defendant is basically non-existent. Texas has largely dispelled the idea of a burden for most people unless they have a specific burden that would make it hard for them to represent themselves in a foreign state. But with the internet, with Wade having the ability to contact a lawyer in Washington, D.C., clearly he has the resources to go ahead and prosecute or to be represented without much burden at all in the forum state. The interests of the forum state. Well, it's a Texas contract between 2 Texas people. They have a lot of interest here. The plaintiff's interest in obtaining relief is obviously massive. It's the one thing that most matters. The interstate judicial system's interest in the efficient administration of justice. Everything about this case except Mark Wade happened in Texas. And the shared interests of the several states in furthering fundamental social policies. This one doesn't really matter in this case at all. So long story short, if they can show general or specific jurisdiction, they certainly can show that it won't violate traditional notions of fair play and substantial justice. That said, let's look at the 2 very important pieces of evidence, okay? First is an interview that Mark Wade did with Bleeding Cool explaining his phone call. And I've just snipped out a relevant portion of it. This is interesting because they talk about how Wade has no ongoing and systematic contacts with Texas, has no business contacts with Texas, no contacts with Texas at all, right? This is what Mark Wade says he said to the owner of AP. I offered to, once the dust settles, conduct an interview with him for publication where we can talk about the choices he's made here and the thinking behind them. He is offering to engage in an agreement with a Texas business person to do an interview for publication. Publication is business. Publication is Mark's business. He identifies himself as a publisher. Yes, he's offering to do business with a Texas resident right there. He's offering to engage in continuous and systematic contact with a Texas company resulting from his tortious interference. So there you go. That's a problem for Wade, a huge problem. Finally, here is his contact, or here is something that he said in Texas at Comixpalooza. In Texas, Mark Wade said this. There was a publisher here in Texas that was going to publish their Myers comic. There was a huge amount of hatred toward that publisher at the moment. Most people in comics, most fans of comics were looking at this as, what are you doing? They're indefensible human beings. They harass women. They harass minorities. They harass LGBTQ people. They're full of hate. What are you doing? My feeling is let the baby have his bottle. I don't care who publishes a comic. I don't care whether you publish his comics or not. I don't care. But I knew this publisher, and I don't think that he was aware why all of a sudden there was a gigantic groundswell of hate towards him. I knew this publisher in Texas, here in Texas. He's in Texas making these statements about Meyer, which he says he didn't do. So I said, before we burn his place to the ground in Minecraft, let me call him and find out what's going. I know the guy and want to make sure he knows why the hordes of hell are descending upon him. He knows him. He knows this guy. He knows that his business is in Texas. It's right there. This was in May. This was right after the events. He's making these statements in Texas. Now, I don't have it snipped out, but earlier in the interview, he talks about Meyer distributing the list, or Comicsgate people distributing the list of stores. This is the defamatory claim that's listed in Meyer's complaint. He's talking about it in Texas to a Texas audience. He's talking to it about a Texas person. All of this happened in Texas, despite them saying that it didn't. So we can tell that this is a huge problem for Wade's jurisdictional argument. I think that Meyer can, in his response to this motion, he can certainly argue that Wade has significant contacts, has intended to engage in further contacts in Texas with Antarctic Press in the form of an interview for publication as a publisher, that he intends to attend further comic conventions and go to specific comic shops to do signings and to otherwise market himself and his business to comic consumers and publishers and comic shops. There is no doubt that Wade is intentionally engaging in business in Texas, has been and likely will in the future. So, long story short, I think this motion fails. There's a possibility that Texas will not extend specific or general jurisdiction over the defamation claim. That's a possibility. I think over the tortious interference, there's no doubt it'll happen. And I think with those pieces of evidence, including the statements made in Texas about Meyer and about the contract, and the alleged defamatory statement about Meyer publishing a list of people for the purposes of harassment, I think those statements made in Texas about Texas people and Texas events would certainly put jurisdiction there, but it's possible that Texas won't do it in that way. Oh, it also means that Wade lied under oath in his affidavit when he said, let's go specifically to that real quick. It's just in paragraph 5 here. I have not made any statements regarding plaintiff while I was in Texas or otherwise engaged in any conduct while in Texas involving plaintiff. Lie under oath in his affidavit. Now, maybe it's a misstatement. Maybe it's an honest mistake. But he clearly did those things. He actually did those things. I've just shown you where he did those things. He acknowledged he was in Texas when he did those things. It can be verified at Comic Palooza. It can be verified at the shop where he went to sign books. All of that happened in Texas. So these are all from Mark Wade's own words, no allegations necessary. I hope you guys found this informative and helpful. This is probably not going to be dismissed on jurisdictional grounds, at least not the whole thing. It's possible the defamation will be jurisdictionally relocated to California, although I think they would still host it in Texas and just analyze it under California law. But we'll see. We'll see. And we'll see what Meyer's team comes up with. Thanks, guys, for hanging out. I hope you enjoyed this. Y'all have a nice day. I'll keep covering this as it goes on. If you have any other questions, please drop them in the comments. Maybe I'll do a stream soon where we go through all 83 pages of additional information. You guys have a good night. Peace.